the court asked the juvenile prosecutor to answer to why they wouldn't give us this evidence.
And they said they would not be giving the evidence.
They refused.
Yes. People think that the law means that if there's exculpatory information, if it's a juvenile, too bad, so sad for your client. This has been going on for over a year.
You're basically telling the court, it doesn't matter what you tell us, we're not giving you.
Oh, yeah, we'll see about that.
When we're not prepared to sign a discovery acknowledgement today because there is media that's too large to be shared through the portal and we need to provide an external USB.
All right, Ms. Ferguson, if you can recall this back in December for discovery. All right, December 3rd. We're dressing appropriately for court.
Thank you, Your Honor.
We're actually here for discovery, and there are some cases that have not been indicted.
Your Honor, we're still getting notices of additional discovery being uploaded as early as last week.
Okay.
So there are still things being uploaded to the portal. I would not say that we are done with the discovery exchange quite yet.
This is going to be everybody's final discovery date. A co-defendant is in juvenile still?
My understanding is, Your Honor.
So I know there's some sort of issues or complications in getting discovery for that February 10th. It's supposed to be final discovery. So where are we on discovery?
Judge, we've actually filed a discovery motion because the co-defendant of sorts was a juvenile. The case has already been adjudicated. So we wanted to, and those records are not readily available to me. So we're requesting information from his file.
What are your questions?
Well, actually, I'd like to see all of it, Judge, because I don't know what I'm missing until I see it, right? What if he gave a confession? What if he gave a statement? I know we're not getting into the facts, but he's the main actor in this deal, and he's pled to the ag robbers.
Well, state if you could see whether or not there was a statement made by him. I don't know if it should be recorded if it's a juvenile.
Well, Judge, just I know this. I mean, I think Ms. Martinez is correct to say if it was given later, because at the time of the investigation, he did not speak with police. I know that's part of the facts, but he didn't speak with the police. So we know that there's no statement there. But I can look into definitely getting the plea paperwork and the stips and everything. I don't know how to do it over there.
So we're going to bring it back on March 6th. There's something about juvenile documents transfer requested. Yes, where are we?
Well, it seems to me that we were assuming that because he was a co-defendant and because they were prosecuting him more rapidly because the juvenile system works differently, that they could just transfer their crime scene videos, all the things that they had, just transfer over to us, and they give it to me, and it's all good. But that juvenile had so many aggravated cases that they actually pled him on some other ones and didn't really pursue the ones that my client's co-defendant on. So they don't really have much to give us.
Okay.
So I think what has to happen is maybe the state has to send an email to the detective. Can you please send us everything you've got on those particular robberies that are in this court?
And that's something I probably need to give a try about exactly which ones. I mean,
Okay.
I'm doing most. I think both of us are doing the roll call from memory today. But I mean, if you don't mind, Judge, if we could go off the docket and we could actually get together and discuss that until the next step.
All right. I can bring you back on May 5th.
May 5th is good, Judge.
All right. So May 5th for discovery. All right. So do you have all the discovery?
We don't, Judge. That's the reason we've been getting rescheduled, because the juvenile had so many cases. The juvenile, they actually resolved his matters.
And who is the juvenile? Is that the co-defendant or?
The co-defendant, yes, Judge.
Judge, so regarding the juvenile co-defendant, we reached out to the juvenile division of our office. They represented to us that because the juvenile also had a large amount of cases, that they worked out cases that were actually charged in the case at the time when they reached the plea deal. The cases that are involving this defendant were not actually formally charged, and they never received any evidence for them, and they were resolved with the plea deal. And so there's no additional evidence at the juvenile pending.
Well, Judge, that doesn't mean they don't exist. In fact, the state suggesting that the investigating officers just gave up working on the files and never submitted them. They'll tell us that, that's fine, but I still want that evidence. This juvenile was charged with over 10 aggravated robberies, maybe as many as 15 or 20, right? He's a serial aggravated robber. My client was only charged in one day, and we believe we may be able to raise a duress defense and other things like that. So the big picture of what happened with that juvenile and what he was up to and what he did would be very enlightening for the jury. And it could be even exculpatory in terms of me being able to prepare my arrest defense.
All right, so who's the prosecutor who handled that case? And is that the person you're reaching out to, that prosecutor?
We reached out to the investigator and the prosecutor, I think.
Then this is what I suggest we do. If that prosecutor is over in juvenile, still in juvenile, then of course they can't be here. They can appear by Zoom. To the prosecutors in juvenile, with regards to the cases that were taken in consideration, are there any police reports or DVDs or any type of body cameras or discs related to just those specific cases?
Your Honor, based on the family code, any juvenile matters, any prosecutor records, because Mr. Martinez does not represent the juvenile himself, he needs to go to the juvenile court, and he needs to make his argument to the judge to have us release anything to him.
So what you're saying is, according to the family code, he's not entitled to a police report?
He's not entitled to the prosecutor's file unless the judge that has jurisdiction over the juvenile court binds it that he has a legitimate interest in it. And this is an argument he has to make to Judge Shaw.
No,
and at that point, we can release whatever we have.
All right, so your argument is he's not entitled to the police reports that were filed, and he's not entitled to any body camera that are associated with the case that was taken in consideration.
Correct. Because it is a juvenile case.
I don't think the onus is on me to go plead for it. I think
Yes.
I guess the better question is the state going to oppose my request if I make it?
We don't have them.
Oh, they're not going to oppose it. They're not going to say anything. He wants to know if you're going to oppose his request
It's
when he makes it.
That one's 21 pages. It's not necessarily whether we're going to oppose it, but that the judge has to find legitimate reason.
No, I understand that, but are you going to stand before the judge and say, Your Honor, we don't think there's a legitimate reason for this? That's what he wants to know. Because I think we all know.
I'm sorry to interrupt you.
No. I think we all know if the state's attorney were to stand before a judge and say, we are opposed to this, the judge is going to take that into consideration. So he wants to know, if he goes and he requests it, are you all going to say, we're opposed to his receiving the information? I mean, if you are, that's fine, but he wants to know it beforehand.
I understand that. And until I know what his legitimate reason, I understand what he's saying here, but what's written in the motion will determine what we say to the judge.
So they're going to oppose it.
So it sounds like that.
So this is what, you can go there, you can do that, or either, you know what you can do? You can subpoena all of those police officers, and if you want to have a hearing and subpoena all those officers and force them to bring in the police reports they made, the body cams that they have, then the court will make a ruling.
And I see the logic of your suggestion, Judge. The problem is, if I don't see the file, how do I know that I have all the officers?
Mm-hmm. Well, this is what we can do, and I've done it before. Do you know of any of the one officers who were involved in that case?
Oh, of course, I have my discovery from.
All right, so this is what we can do. We can set it for a hearing in this court because they've told you they're going to oppose it, right? So I think once they speak to their supervisors, whoever they speak to, they're going to oppose it. So just subpoena whatever specific officer you want to subpoena, bring them here in the court, and you can go over there and complete file with them and tell them you want body cams, you want this, whatever you want, and then I'll make a ruling on whether or not it's admissible. I'm trying to cut through all of the red tape because otherwise what's going to end up happening, you already know. You're going to go over to juvenile. You're going to go before Judge Shaw. The state is going to object to your receiving this information, and you're going to have to make whatever arguments you want to make over there. But just let me know what date you want to have that set for.
Okay.
Spend all day speaking to whatever witnesses you want to subpoena, and we can go through the police report line by line and make sure that you have the information you need in order to go forward on a jury trial if your client so chooses. So have you received all discovery?
There still hasn't been a resolution, and I think the state's position, not necessarily this prosecutor, but the juvenile prosecutor position is they're just not going to do it. So,
All right, so I thought we were supposed to have a hearing with them.
we did. And
Well, I know they were by Zoom saying they're not going to give it, but I said subpoena it.
We did. And I don't think their position hasn't changed. They're basically telling the court, doesn't matter what you tell us, we're not going to give it to you.
Oh, yeah, we'll see about that.
Yeah. But we're trying to get around that problem by seeing if we can resolve some other cases. And we've been exchanging information and trying to get there.
All right, so I would suggest follow subpoena and subpoena the documents, and they'll have to file a motion to quash, and we'll have a hearing, and they'll have to rehear.
I can't make an informed decision without having those documents either. And I mean, I've tried to facilitate between this subsection of the office and that subsection of the office, and even in other cases, they just won't provide me with the discovery.
It seems like, and I'm fine with that, us having that meeting, but records is a matter of law, or just not open records. I can't subpoena things that.
No, I understand what you're saying. They'll have to file a motion to quash. I mean, people, you can file a subpoena on whatever you want to subpoena, and you can let them know that they're not allowed to appear by Zoom, so they'll have to be in court. We can get conversations started. Legally, they'll have to file a motion to quash, and they'll have to come in and have it heard.
But I will do it because court's asked me to do it.
Because who knows? They'll show up, and maybe they can tell you all things as opposed to giving you documents. So we're going to come back on August 21st for motions. So where are we? I know you were in jury trial. This is the case where the juvenile motions and everything.
But Judge, what I did was I contacted David Noonan, the chief of the felony prosecutors. He gave me a template of a motion to file. Apparently, there's a procedure in the juvenile court to get the judge in the juvenile court to approve the release,
Yes.
which if the juvenile prosecutor told us that 2 months ago, would have already been done.
Because I knew there was a way to do it. So I
I
was just,
drafted the motion.
okay.
The only thing that I'm missing is the case number in the juvenile court, because apparently you can't even get that information, but I'll try. And so my goal is to get the coordinator in the juvenile court to set me on the docket on my motion. If they grant it, I get what I need, we're done. They deny it, we'll be back here to talk about all the ramifications of that. That's,
Okay. I don't think they're going to deny
I
it.
don't think so either, Judge. We just haven't done the process.
All right. Ms. Ferguson, set this late September. All right. That will be final discovery. And I'm sure that that judge will approve for him to have those records. And they'll probably do it with a protective order attached to it. So what's happening with this case?
We went to the second hearing. Judge Shaw has finally agreed to let us physically inspect both the court's file and the state's file, and then come back with more specificity if I want something duplicated. We would request at least 2 weeks for me to physically be able to go down there and look at it. The state has no objection to letting me go and view those. And that's as far as we've gotten since the last setting, Your Honor. But we did make that progress.
All right, Ms. Ferguson, I need to set for a jury trial date and a plea deadline date, and y'all can get a setting in February. All right, your jury trial date and your plea deadline date is going to be February 17th.
We still have tremendous discovery issues. I still don't have anything that I've asked for in terms of juvenile records. Matter of fact, the state gave me a listing of like 10 or 12 police reports. I've made my own request to the city, and they send me a letter back. We're not going to give it to you. So I keep running into the same merry-go-round. So, not only the state refusing to give it to me, but the city's refusing to give it to me. And I've thought about this backwards and forwards, and I think it's just an extremely unique situation where a juvenile is a co-defendant, here he is, Judge, with an adult, and cases actually maybe go to trial, et cetera, et cetera.
So the person who was sent to TDC, was it because of juvenile issues or something completely different?
He had more than 10 aggravated robberies. 5 of which my client is codependent and the others he's not, right? But they won't give me access to anything.
There is a motion you can file to get those.
We've already had.
I'm gonna pull into my memory bank. No, there's something else, because I just remembered I had something similar to this when I was a defense attorney. So I'm just gonna pull it from my memory bank and I'll let both sides know. And then whatever you all want to do, you can do. All right, Ms. Ferguson, on this case, did they do the bench warrant today?
I haven't done it yet because I just got that information like within the last 10 days.
All right, Norma, how long does it take when a bench warrant is signed?
Maybe 10 working days, just bring the defendant.
All right, so let's recall this in 20 days, and I'll sign that.
And I'll try to follow up. I did file a motion for the bench warrant, so I need to go find the order so I can get you to sign it. And I can tell you, Judge, I also have a motion to dismiss on file the trial grounds. This case is from 2020.
It's March 9th.
All right.
It's going on 2 years.
All right, State.
Yes, sir.
On this case, this is going to be called for March 9th. See about the bench warrant. And then we can hear their issue where they're requesting a dismissal for want of a speedy trial. And that has nothing to do with this court. I'm assuming it has something to do when it was filed.
It's been indicted for more than a year, Judge, I'm sure.
Okay.
So we actually had a hearing in front of the juvenile judge, and he denied us as well. Cover every base we can cover to try to get these records.
You know what? So here's my question for the juvenile people. If you have information that somebody is not guilty of an offense, you're telling me I'm not going to turn over any records because...
Well, it gets more complicated than that, Judge.
All right. We'll be back on March 9th, and the court will hear motions on that day, and we'll see where we are on the bench warrant.
What began as a routine court appearance instantly turned into one of the most shocking hearings of the day. As the judge read the allegations aloud, the courtroom fell silent. The charges weren't minor mistakes or simple misunderstandings. They involved accusations so serious that they could change a person's life forever. Despite the gravity of the allegations, the defendant insisted he was innocent and made it clear that he intended to fight every charge. But this hearing wasn't about proving guilt or innocence. Instead, it was about a decision that could send him hundreds of miles away to face the court where the case began. As the judge carefully explained the extradition process, the reality of the situation started to sink in. One decision, one signature, and the next chapter of this legal battle would begin. Now the questions remain. Are these accusations exactly what prosecutors claim they are? Or is there another side to this story that has yet to be heard? Only the evidence and the courtroom will decide. One thing is certain, the road ahead will be anything but easy. Do you believe the defendant's claim of innocence? Or do the charges raise too many red flags to ignore? Let us know your thoughts in the comments below. If you enjoy real courtroom drama, shocking legal cases, and unforgettable judge moments, make sure to like, subscribe, and turn on notifications so you never miss a new video.